Welcome back to Winning Isn't Easy. Is the federal judge's job in reviewing an ERISA disability insurance claim to weigh the evidence or to determine if there's a reasonable basis for the claim's denial? Unfortunately, it's not uncommon for ERISA disability insurance or plan claims that have been denied or terminated to end up in federal court. Now, I find that most policyholders and plan beneficiaries don't understand the role of a federal judge in an ERISA disability lawsuit. Before I explain this, I want to contrast the role of a federal judge with that of a state law judge. If you bought your disability insurance policy through an independent agent, or if you have a plan that is a church plan, or you got your benefits through your employer who is a state or municipal agency, most likely that claim is not going to be governed by the ERISA statute. And that's great news for you. If your benefits are denied or terminated, you can file a lawsuit in federal court alleging that there's been a breach of contract and a breach of fiduciary duties that the carrier or the plan owes to you. These claims are heard by a judge or by a jury. Now, if you decide to have a judge decide your claim, then the judge becomes the trier of fact and plays an important role in the case. The question for the judge, or better yet, if you choose a jury, is whether or not the disability carrier plan breached its contractual and fiduciary obligations to you, and if so, what are you owed? Now, you also, by the way, can claim interest and costs, bad faith damages, depending on what state you're in, and even attorney's fees. Now, that is, in my view, the perfect world. Because on the other hand, under the ERISA statute, there is no jury trial. And basically, the judge is limited to looking at what was in the claims file at the time of the last denial or termination. Generally, nothing new can be added. And that's why the appeal is so important. You'll have 180 days in which to file an appeal. And the appeal is really the trial of your case. So what is the role of the federal judge? I want to give you an example in the case of Galvin Bleifernick versus First Unum. It's a case out of Tennessee. Galvin Bleifernick sustained serious injuries as a result of a motor vehicle accident, and she applied for and was paid her long-term disability benefits until First Unum terminated her benefits. She filed an appeal, and ultimately this case ended up in federal court. So the very first thing the federal judge had to decide was what was the standard of review that was applicable that would determine the judge's role. There are two standards of review generally in the ERISA world, and they can make all the difference as to whether or not you win or lose. The first, and the one I love the most, is the de novo standard of review. The federal judge finds that they're not bound by the denial, and they can make their own independent decision about whether that termination or denial was right. But the more common and less friendly standard of review is called the arbitrary and capricious standard of review. If the plan or the policy gives the disability carrier or plan discretionary authority to determine the eligibility for benefits or to construe the terms of the plan, the benefit determination is reviewed under the arbitrary and capricious standard of review. Now, you'll find the answer to which applicable standard of review it applies to you is in the disability policy or plan. There's language that will tell us which standard of review it is, and obviously that's something that we want to know right away. I wish I could say to you that arbitrary and capricious sounds like arbitrary and capricious. It isn't. A decision is not arbitrary and capricious if it's possible to offer a reasoned explanation for the decision based on evidence, and their decision to deny or terminate benefits is a result of a deliberate, principled reasoning process and is supported by substantial evidence. Now, that sounds great, but in practice, it isn't. Courts are going to uphold a denial or termination if they rely on the medical opinion of one doctor over another. In other words, there is no treating physician rule, and the disability carrier plan gets to pick which doctor they rely on. Now, I will tell you that arbitrary and capricious can be if the disability carrier or plan ignores key pieces of evidence, they selectively reviewed evidence, they, in certain cases, failed to conduct physical examinations. In other words, they didn't exercise their rights to an IME, or they really rely heavily on the non-treating physicians, and that physicians that they're relying on are not necessarily competent or qualified. So you got to understand that a decision is not arbitrary and capricious just because the carrier or plan accepts their liar for hire opinions over that of your treating physicians. Remember, they've created that substantial evidence by hiring liar for hire doctors, and they'll do multiple reviews by multiple specialists in an effort to convince the judge that they have actually engaged in behavior that is reasonable, that's appropriate, and that they have considered these well thought out medical opinions that differ from your treating physicians. I will tell you that unfortunately courts rarely look behind this denial game, and they really either don't want to or don't understand the games that disability carriers play, like Unum, in creating evidence. I find there's rarely anything that's principled about this process, and because they're creating this evidence, they use the same physicians or peer review companies over and over. There are many doctors who report all you really have to do is change the name of the policyholder, and they say the same thing. One of the things that we have done in our practice is to collect the opinions of these common liar for hire doctors and kind of track what they have to say, so that if we have a certain doctor who's been used by the carrier or a different peer review company, we've got a ready-made argument attacking these physicians or providers because we've been tracking all of this evidence. Does that necessarily mean the judge is going to agree with us? No, not always. But you need to understand that it is not the court's job to weigh which party's evidence was more credible or reasonable, only to determine if there was a credible basis for the decision. And as could be expected, the judge upheld the denial. The standard of review can make all the difference. And so let me give you an example of how it works in the 11th Circuit, which is where we're primarily based, which is Florida, Georgia, and Alabama. And I'm going to boil it down to 3 questions. The standard is a little longer than that. But as I explained to my clients, the first question is, does the judge agree or disagree with the decision? If the judge agrees with the decision to deny or terminate benefits, you lose. The next question is whether or not there's enough stuff in the carrier's file that explains why they did what they did. Not whether or not the judge agrees with what the carrier did, but is there enough substantial stuff to justify the claims denial? That is where those liar for hire doctor reviews come in. If the judge says, look, I don't like this decision, but I see that there's enough stuff in the carrier file, you lose. Then what happens is if the judge says, look, I don't like this decision, I don't think there's enough stuff in the file, then the judge has to determine whether the decision that the carrier or plan made to deny or terminate benefits was influenced by their dual role as the decider and the payer. Now, at least in the 11th Circuit, it can be hard to get to this information about bias. Did the liar for hire doctor issue 10 other reports that say the same thing? Did the liar for hire doctor get a bonus? Did the claims adjuster get a bonus? How many times do they use this liar for hire doctor? There is a case called Howard versus Hartford out of the 11th Circuit that makes it difficult for us to get at this bias. Now, other circuits have different standards of review, but again, in the 11th Circuit, we have to establish to the judge's satisfaction that the decision is wrong, that it's not justified by the information in the file, and that the decision to deny or terminate benefits was influenced by their bias and conflict based on their dual role as the payer and as the decider. You've got to meet all 3 or you lose. So you can see that this standard of review, this arbitrary and capricious standard of review, makes it very difficult for a denied or terminated policyholder or plan beneficiary to win. Got it? It all comes down to the standard of review. I hope you've enjoyed this week's episode of Winning Isn't Easy. If you've enjoyed this episode, please like our page, leave a review, share it with your family or friends, and of course, subscribe to this podcast. This way you'll be notified every time a new episode comes out. I hope you tune in to next week's episode for another educational and insightful episode of Winning Isn't Easy. Thanks.